Okay, good morning. Welcome to the Office of Tax Appeals. This hearing is for the appeal of Jennifer E. Stackpole Family Trust. Before we go on the record, I want to go over some housekeeping items. Please silence cell phones and laptop keyboards. It's F1 on the keyboard when not speaking. The hearing is being live streamed on OTA's YouTube channel. This hearing is being transcribed. To ensure we have an accurate record, we ask that each person speaks one at a time and avoid speaking over one another. Also, please state your name before speaking and speak slowly, clearly, and loudly. If needed, I will interject to ensure proper transcription. After the hearing, an official hearing transcript will be available on the Office of Tax Appeals website. The Office of Tax Appeals is not a court, but is an independent appeals body, which is staffed by subject matter experts and is independent of any tax agency. While the Office of Tax Appeals is not a court, we must nevertheless follow certain guidelines to ensure that we have established a proper record on which a decision is based and to conduct an orderly hearing. Each party will have the opportunity to be heard, so please wait for your turn to present your side. Also, I may interrupt the hearing if we get out of order or become counterproductive, as keeping us on track and creating a clean record is part of my role. Any questions before we begin? All right, seeing none, we are going on the record. This is the appeal of Jennifer E. Stackpole Family Trust, U/A, dated May 10, 2002, OTA case number 241218189. The date is July 23rd, 2025, and the time is 9:35 a.m. This hearing is being held electronically with the agreement of the parties. I'm hearing officer Kim Wilson. This case is being heard and decided by a single hearing officer under the Office of Tax Appeals Small Case Program. I'm going to ask the parties to identify themselves and who they represent, starting with appellant. Also, if you could please spell your names for the record. Mr. File, you're muted.
How about now?
Great.
Okay, sorry about that. My name is Eric File, P-F-E-I-L, and I'm the trustee of the Jennifer Stackpole Family Trust. With me is Seda Khan, K-H-A-N, and Seda is the CPA who is responsible for filing the year 2023 tax return for the trust.
Thank you. And respondent?
Good morning. My name is Leo Cristobal, Leocristobal, and I represent Respondent Franchise Tax Board.
Thank you.
Good morning. My name is Maria Brosterhouse, and that's spelled Brosterhous, and I'm also with Respondent Franchise Tax Board.
Thank you. As stated in the minutes and orders, the issue to be decided in this appeal is whether appellant has established reasonable cause to abate the late payment penalty. Appellant submitted exhibits 1 through 8. FTB, do you have any objections to the admissibility of these exhibits?
No, we do not.
Thank you. Exhibits 1 through 8 are admitted into evidence. FTB submitted exhibits A through D. Appellant, do you have any objections to the admissibility of these exhibits?
No.
Thank you. Therefore, exhibits A through D are admitted into evidence. Ms. Khan and Mr. File, you will have 15 minutes for your presentation. You may begin when you're ready.
As I indicated before, my name is Eric File, and I'm one of the 3 trustees of the Jennifer Stackpole Family Trust. In addition to being one of the trustees, I'm also counsel for this trust. And as I also indicated before, with me is Seda Khan, the CPA who prepared the tax return in question for the trust. I'm also an enrolled agent before the IRS, as the law firm that we work for prepares and supervises the preparation of over 700 returns annually. The matter before this body involves the imposition of a penalty for failing to timely pay the balance due with the 2023 California fiduciary income tax return for this trust with the return when the return was filed. There are no other issues. A few facts are relevant to this appeal. This trust was formed in calendar year 2002 by Jennifer Stackpole's mother, who was a resident of Pennsylvania, for Jennifer's benefit. And because this trust was created by a Pennsylvania resident, Pennsylvania law requires that this trust is required to file a Pennsylvania fiduciary income tax return for the trust. And as such, the trust has filed fiduciary income tax returns for this trust for every year since 2002 and paid all necessary taxes to the Department of Revenue in Pennsylvania. When Jennifer Stackpole, again, who is a co-trustee and a beneficiary of this trust, moved to California, as required by California tax laws, we immediately began to file California fiduciary income tax returns for this trust. These returns were all timely filed, and all taxes associated with these returns were timely paid, with the exception of the balance due with the 2023 return. In April 2024, we caused to be filed a federal and California fiduciary income tax return for the trust, providing the bank account information that had been provided to us by Fiduciary Trust Company, the bank where the trust funds are held, so that any tax payments, federal or California or Pennsylvania, could be electronically withdrawn by the taxing bodies. On April 17th, 2024, as evidenced by the Fiduciary Trust Company statement that we provided as evidence, the United States Treasury withdrew the balance due for our 2023 federal return for the trust, as well as the first quarter 2023 estimated taxes, 2024 estimated taxes. For some reason, unbeknownst to us, California Franchise Board withdrew neither the balance due for 2023 nor the first quarter 2024 payment. Also of relevance, on June 17th, 2024, the California Franchise Tax Board electronically withdrew the first quarter 2024 payment from the fiduciary trust account for the trust using the same information that we had provided on the tax returns to the feds as well as to California. And that withdrawal is reflected on his June 17th withdrawal on one of the fiduciary trust company statements that we provided to you. Sometime in early July, we received a notice advising us that there was a balance due for 2023 from the California Franchise Tax Board. We promptly investigated, and after discovering that the payment had not been made, we immediately manually paid by check the balance due for 2023, as well as the first and second quarter 2024 payments, not realizing that in June, the Franchise Tax Board had withdrawn one of those estimated tax payments. So basically, we recognize that the purpose of imposing penalties for tax filings is to encourage compliance with the tax laws. We're not doubting that at all, but as your records will indicate, we've done nothing but be compliant in our filings and our payment of taxes for this trust. For some reason, unbeknownst to us, the United States Treasury was able to withdraw the funds from our bank account using the same exact account number provided to the franchise tax board. And we understand that a taxpayer has a personal, non-delegable obligation to pay tax by the due date of that return. That being said, when the same banking information is provided on the federal return, the California return, and the Commonwealth of Pennsylvania return, and California is the only entity that failed to withdraw the funds as requested, I submit that the imposition of the penalty is not justified given the exemplary history of tax compliance by this trust. And that's the end of my statement.
Okay, thank you. That's your presentation?
Yes.
Okay, thank you. We'll go ahead and go with the Franchise Tax Board. Mr. Criswell, you'll have 10 minutes for your presentation.
Thank you. Good morning. Like I mentioned previously, my name is Leo Cristobal, and I represent the respondent Franchise Tax Board, or FTB. As has been mentioned, the issue in this case, the sole issue in this case is whether appellant has met its burden to prove, a burden of proof, excuse me, to establish that its failure to timely pay the tax due was due to reasonable cause and not willful neglect. Appellant is a trust that filed its 2023 tax return on time. However, appellant's tax was not paid on time, and when a trust fails to timely pay its tax, FTB is required to impose a late payment penalty. When FTB imposes this penalty, the law presumes the penalty was imposed correctly, and to overcome this presumption, appellant has the burden to establish that its failure to pay timely was due to reasonable cause and not due to willful neglect. In this case, appellant highlights the fact that it was able to make successful payments on prior occasions. However, FTB in its briefing has demonstrated that appellant's attempt to make payment of 2023 taxes due to FTB by the April 15, 2024 deadline was rejected because appellant inputted invalid bank account information. Unfortunately, an oversight that causes a failure to timely pay a tax balance does not by itself constitute reasonable cause. Appellant argues that it only discovered the failed payment after receiving notice from FTB, points to its good compliance history, and asserts it did everything in its capacity to pay timely. However, it is well established that a lack of notice from FTB regarding a failed payment does not negate the duty of prudence and due care to verify that a payment was successful. The law is clear that reasonably prudent taxpayers exercising due care and diligence are expected to monitor their bank account and quickly ascertain whether a scheduled payment was in fact paid from their account to FTB. Here, if appellant had monitored its account after April 15, then within some days, appellant would have realized its payment did not leave its bank account for the payment in question. And from there, appellant would have been able to quickly correct the error. In contrast, appellant did not rectify this error until approximately 3 months later. In conclusion, appellant has not carried the burden of proof that its late payment was due to reasonable cause. Accordingly, appellant is not entitled to penalty abatement, and FTB's action denying appellant's refund claim should be sustained. Thank you, and I'm happy to answer any questions you may have.
Thank you. I don't have any questions. Mr. File and Ms. Khan, if you'd like to present a rebuttal, you have 5 minutes.
I'm not sure that we could do too much more than we did. I mean, granted, we did not monitor the withdrawal of the payment that should have been withdrawn by the California Franchise Board. And I would submit that most taxpayers do not monitor their bank accounts to determine whether a taxing body who is given banking information would have reason to know that the payment wasn't withdrawn as requested. So I think under the circumstances, particularly given the fact that California Franchise Tax Board and many taxing boards have not been doing things according to military procedure and on due dates where the payment gets withdrawn from the amount, within even a day of filing the return. I don't think it's not unreasonable to say that we fell on our laurels and we didn't do this properly, particularly given the fact that the California Franchise Board withdrew funds in June 15th, which says that they had the correct tax number. So, I submit that we have been model taxpayers and we did everything possible. And as evidenced by the fact that a June 15th payment was withdrawn by the California Franchise Tax Board, I submit we did everything that we needed to do. And I believe we have met a reasonable burden, and that the purpose behind imposing a penalty is not the situation we have before us. I mean, right now you have someone who has tried for years and years to be compliant with the tax laws. And if the purpose behind this is to correct my behavior, I'm not sure what kind of behavior can be corrected, because everything that we were asked to do, we promptly did. The only thing we're asking for is an abatement of the penalty, for the simple fact that there are reasonable circumstances here that someone reasonable on your side looking at should be able to say, this is not the taxpayer that we want to be going after for penalties who's been compliant with the law. That's the end of my statement.
Thank you. I do have a question. You mentioned in your briefing that the tax return preparation vendor, CCH support,
Correct.
has confirmed the ACH debit was set up correctly. Can you explain this or elaborate more on that statement?
Yes, this is Saida Khan, Khan, and I have reached out to CCH because, to make sure that we did everything, the input was correct. And as Eric has mentioned, IRS was able to withdraw the payments, and they confirmed in many pages of that this was correct. So we did everything that was correct, and California to us failed to withdraw. And how come the June 17th payment was also automatically withdrawn by California? And how the April payments were not? So, CCH has confirmed with us that the input was correct, the account numbers were correct.
And can I add one thing to that? And that
Of course.
is, we went to our bank and asked them to provide us in writing with the account number to reflect on the return, which we did. And we subsequently, when we found out that there was a problem here, went to CCH to find out if in their mind that there was something that was done incorrectly. And again, as Seda just indicated, they found no fault with anything that we did as far as the inputting of that information. So we believe that we did everything in our power to be compliant. And when we found out that there was a problem, we made sure that the California Franchise Tax Board was paid immediately with interest and penalty.
Okay. Ms. Khan, for the tax software, when you make your estimated payments for the following tax year, is that number already put in, or do you have to re-enter?
No, it's in there. We don't have to re-enter. It goes from year to year.
So it's a carryover from the
2025, yes.
prior,
Yes.
okay. Thank you. Mr. Cristobal, could you explain maybe how the FTB could receive the June payment, but not the April 15th payment based on appellant's testimony or
Yeah, so I can speak specifically to the April payment. I want to reiterate that our records show and the exhibit that we submitted confirms that that payment attempted in April. It was rejected, and the reason was that an invalid account number was submitted when that payment was attempted. Now, all I can speak to as far as a June payment that was made subsequently and successfully is that we don't have a similar report showing that that number or that payment in June was rejected for an invalid account number being inputted. So as far as the question as to whether and why those two, one payment went through and one did not, the one that did not, we have a specific piece of reporting in our record showing that it was rejected for that reason, which was an invalid account number was inputted.
and the to follow up, the reason it was rejected, it was the bank that rejected it, or the franchise tax board submitted a request, but it didn't go through. Is that?
It wasn't the bank. This is Saida Khan. It was FTB that rejected, and we did not get a report from FTB about the rejection until the July notice. And in the meantime, the June payment did go through without any changes.
Okay. Mr. Cristobal?
Yes, to clarify, what this means is that the number that was provided to FTB, the account number and routing number, there was an error somewhere in there where when those numbers are provided to the bank was not able to process the attempted payment.
Thank you. I don't have any other questions. Ms. Khan or Mr. File, would you like to have one final say?
As I indicated before, we believe we did everything that a dutiful taxpayer could do. I always, in a situation like this, I go back and say, what could I do to change the outcome of this? And under the circumstances, I don't know that I could do much. And so we believe that we acted reasonably, and we didn't do anything to try and shirk our responsibilities to the state of California. And so we're very hopeful that the Franchise Tax Board will look at this and reflect upon the fact that we have done everything that we could, and we continue to try and do that. We'll do so in the future. And so we'll hope for a good outcome. We thank you for your time.
Thank you.
Thank you. This concludes our hearing today. The case is being submitted today, July 23rd, 2025. Record is now closed. Thank you, everyone, for participating today. I will issue a written opinion within 100 days from today. This hearing is now concluded and OTA is in recess. The next appeal